Welcome to Lawgical, the UAE's first and still the only regular legal podcast. My name's Tim Elliott. Lawgical comes to you from the Dubai-based legal firm HPL Yamalova and Plethka, and as always, here's the managing partner, Ludmila Yamalova. Nice to see you.
Good to be here with you, Tim.
Today it's end-of-service benefits for domestic workers in the United Arab Emirates, Ludmila. And before we get to kind of the nitty-gritty, if you like, of the subject, would you do something for me? Just define the term domestic worker. How is it defined under the law?
So domestic workers in general terms is defined as those employees who work in the house representing or providing services to the family.
Right.
Of individuals. And so it's less about the specific definition of domestic, or the term of domestic workers, but more by it's defined in terms of examples who are considered to be domestic workers. So they could be nannies, they could be chauffeurs, or drivers, chefs, gardeners, cleaners, maids, teachers. They could even be personal trainers. And nurses. So they are defined as, generally speaking, as domestic workers. But ultimately, the defining as parameters is that these are people who usually they even live in the house, but they work and live in the house and representing and taking care and servicing the needs of people who are families. In most cases, they live in the house. They don't have to live in the house, but certainly whatever the work they do, it is for kind of personal, for domestic needs or personal needs of a family and family members.
Okay, we've talked about domestic workers' rights a number of times on Lawgical, but this is new, almost kind of breaking, as it were. There's no mention of end-of-service benefits in the new law, the federal decree number 9 of 2022 on domestic workers. That came into effect at the end of last year. Now, this was something you remarked on at the time. And if I remember rightly, you said it was a point that you wanted to come back to in another podcast. So here we are.
And yes, here we are. And just to set the stage why we are talking about end of service for domestic workers is because, as we've discussed before, in the UAE there's a concept of end of service gratuity or entitlement for at least for the most part for all employees, or at least historically was for all employees, but in particular for the employees of private sector and public sector. So, and this is the UAE's version of some type of a pension plan or a severance plan, and that's for expats. So this only applies really to expats, not so much the UAE nationals, but this is the UAE's version for expats to provide for some kind of a additional payment plan and some sort of compensation as a reward for their employment in the UAE. So in technical terms, or I guess in more ubiquitous terms, we referred this to in the UAE as end of service, EOS, or gratuity. And until recently, and maybe you recall, we were one of the few ones, or the first ones. But until recently, the perception was that it's mainly end of service benefits only really apply to employees in the private sector and the public sector. And the public sector usually, these are historically government employees or public sector employees have better benefits, or perhaps a little more generous benefits than the employees in the private sector. But in private sector employees, and they have all been entitled to this, what's called the end of service gratuity. And that's at the end of their employment, as long as, in relevant terms, as long as they worked for the company for at least 1 year, they would be entitled to end of service. And end of service, in most cases, is calculated as about 21 days of basic salary for every year of service. So every year, when you work for about a year, you're entitled to, at the end of your employment, you're entitled to additional about 3 weeks of your monthly salary for every year of service. But for the longest time, and this is kind of important to highlight, for the longest time, there wasn't really a specific law. In fact, the employment law that sets out the end of service for the private sector is the same employment law that the previous version of the employment law that specifically excluded domestic workers. Yet, until 2017, there wasn't a specific law, employment law, that governed domestic employees or domestic workers. So until about 2017, there was only employment law that covered the private sector, and then there was the HR law, which is basically an employment law that covers the government employees. But both laws more or less specifically excluded domestic employees, and yet there was no specific law that would cover domestic employees. Now, in 2017, a law was issued, and that's the Federal Law number 10 of 2017, that specifically set out what this was a specific law for employment law for domestic employees, which was great because it set out all the requirements and entitlements and obligations as they pertain to domestic employees in the UAE. For the most part, in most cases, it sort of mirrors or at least trails the general benefits, the most benefits that are also set out in the employment law for the private sector. So, for example, holidays, and health insurance, and just the treatment of employees, and so on and so forth. So, in many ways, it had a lot of or similar benefits and rights that were given to the domestic employees as those that are provided for employees in the private sector. Among other things, and more importantly, that same law also spelled out the entitlement to the end of service benefits for domestic workers, and that was the big kind of the groundbreaking provision, because until that time, most domestic workers did not even know that they were entitled to end of service. But even when the law came into effect, it wasn't really talked about very much. So I think it wasn't until perhaps we started covering and doing this podcast a few years ago that we started raising this awareness, and this created a lot of exuberance and excitement in the market, because all of a sudden domestic employees realized that, well, they have, in addition to receiving their salary and take it home, additionally, they also had this other payment that they were entitled to at the end of their employment. Furthermore, that particular provision also spelled out that since with most domestic employees, their employment contract is for 2 years, that employment or that gratuity had to be paid to them every 2 years, irrespective of whether they continued or not their employment. So unlike other employees in the private sector, so for example, if you're working on gratuity or end of service, by definition comes at the end of your employment. So if you worked for 10 years, you wouldn't be receiving it until you finished your employment at the end of 10 years. For domestic employees, it was somewhat different. So the law stated that every 2 years at the end of the contract, domestic employees were entitled to receive, and therefore employees were obligated to pay them their end of service. And that end of service or gratuity was calculated as 14 days of every year of service. So in other words, at the end of every 2 years, they would receive additional about 4 weeks of salary, which is about an extra month of salary. So every 2 years, let's say when the nanny or a maid wanted to either renew her contract or go home to see her family, then she, by law, it wasn't always practiced, but by law, employers were required to pay the end of service for the previous 2 years. So that's how it was from 2017, and that was the Federal Law number 10 of 2017. And since we started covering this, there was a lot of excitement, and there's a lot because the domestic employees became a lot more informed. We know firsthand that this was a big shocker to a lot of employers, because they were not aware of the law, and when this was brought to their attention, they obviously many of them either had not planned and not budgeted, or just were not really happy about it. Be it as it may, as time went on and people were more and more informed, these benefits, domestic employees were actually claiming these benefits. And whenever there were disputes that would go to court, then the courts would always award this end of service or gratuity to domestic employees. Then last year in 2022, there was a new law that came out on domestic employees, and that's law number 9 of 2022, and it's called the law number 9 2022 on domestic workers. This law, so it came out only in December, or came into effect in December. So in this law specifically canceled out the previous law, which was law number 10 of 2017 on domestic workers, which we just discussed. And so there's the previous law that set out this framework for the payment, the entitlement and the payment of gratuity for domestic workers. So this new law that was issued and came into effect in December of 2022 canceled out the previous law. Right. Okay, and so then of itself, as we've seen so much legislative evolution and development in the last 2 years, in particular, maybe almost 3 years now since the beginning of COVID, that and most of these regulations have been perhaps significant steps forward in terms of kind of updating the laws to current societal needs. And so the expectation was that this new law for domestic employees would also introduce new benefits, new rights, and would otherwise be a more favorable law. And for all intents and purposes, I have to tell you, it is a much better law in terms of how it's structured, how it's defined. It's a lot more clear than the previous law. It's a lot more specific, targeted for, okay, these are the entitlements, these are the rights of domestic employees, as opposed to the previous law, which talked a lot about the recruitment agencies and what the rights between the recruitment agencies and employers or the families that would be hiring domestic employees is a little less clear about, okay, so these are the rights and these are the entitlements for domestic employees. So this new law, structure-wise, is a lot more clear, and it's a lot more helpful and insightful to domestic employees in terms of what they cannot do, and equally so limitations and restrictions on employers, be it families, direct employers, or recruitment agencies. And so in that way, it's quite a helpful law. With regards to the end of service, however, there's Article 22 of that law. Remember, we're talking about the 2022 law, which is law number 9. With regards, and that's the article that talks about end of service. So, and the reference in this article is that that any kind of end of service entitlements will be discussed, and in the future decision, it will be addressed in the future decision by the UAE cabinet, which would ultimately adopt rules and regulations for calculations and payment of end of service gratuity for domestic workers. That's basically what Article 22 of this Federal Decree Law number 9 of Federal Decree Law number 9 of 2022 states that with regards to end of service benefits, it will be further clarified and further set out and defined in the future UAE cabinet resolution. So that cabinet resolution has since been introduced, and that was just in January, just a few months after the main law came into effect. So in January of 2023, the UAE issued a new cabinet resolution number 106 of 2022, and that's regarding domestic employees. So now, remember, there's the main law, which is law number 9 of 2022, and now there's this resolution to add on or clarify the main law, which is the resolution number 106. So this resolution, however, does not state anything about end of service. So it doesn't make any kind of mention of end of service period, let alone about how to calculate and pay end of service. And that's if you're recalling the main law, which is law number 9 of 2022, the Article 22 mentions that the future cabinet resolution will discuss and set out regulations for calculation and payment of end of service.
Sure. So if I'm trying to get my head around this. So if it's not referred to, you're thinking, is this to come? But you can only go with the law as you see it at that point in time. So this is not referred to at all.
Exactly.
It's not in the law.
It's referenced in very general terms in the main law, to be further clarified and explained in the future law. The future law came out, but it makes no mention or no reference of the end of service entitlements for domestic employees.
So from that, do you take, since it's not yet been referenced, that you have no right to an end of service benefit.
Exactly. So, and what's important is that correct. So there's no more legal authority that exists today on the basis of which a domestic employee can claim gratuity.
Okay.
And this is because in law, you obviously have to, if you're going to make a claim for a right, that right has to exist either in contract or in law. And so in law, if there has to be a law for you to reference to, and as I mentioned earlier, the previous law from 2017, that was law number 10 of 2017, is no more. Because the later law, which was issued in 2022, law number 9, that law specifically basically cancels out, erases the previous law from 2017. So the previous law and the provisions related to end of service and how they were calculated, how they were to be paid, is basically no more. Think of it as a document that is no longer exists, like erased. So that's ultimately what that's the effect of it. So while we know, and a lot of domestic employees learned about the entitlement to gratuity for them in the last several years, and many have claimed, and many are still expecting that to be the case. If they were to claim that today, there's no more legal authority, valid legal authority on which they can rely to make that request or that claim. Furthermore, we obviously there's a few kind of nuances to this. One, well, perhaps there will be another resolution that would be issued to add on to this main law, and that is often the case in the UAE in particular. When the main law is issued, as time goes on, they keep adding more. They either clarify or further define or add on or amend certain aspects of the main law. So, for example, there'll be this one cabinet resolution, but the cabinet can issue other resolutions. So it could be other resolutions that will continue to define other aspects of the main law. So there's a chance there will be another resolution in the future to perhaps address this point or close or this void, because maybe it's just unintentional. We don't know. But as things stand today, the law doesn't. There's nothing in the law right now to kind of hang a hat on with regards to the claim for end of service. Furthermore, we thought, okay, listen, well, maybe since the courts, as I mentioned earlier, previously before the law changed, there were claims before the labor courts by domestic employees for payment, among other things, of of gratuity, and the courts were granting it. So obviously the courts are aware of that law. So we thought, okay, well, maybe the courts will continue to, in the absence of the new law that sets out gratuity entitlement, maybe they will sort of extrapolate from the previous law. So that was a little bit of hope, if you will. Though, to be honest with you, that would not be proper for the courts to do, because courts and judges can only really apply the law. And if the law doesn't state anything, then extrapolating from something that doesn't exist is also questionable. But furthermore, we have since looked and reviewed a number of court judgments in the context of domestic employees' claims, and so far everything we have seen, there's no mention of gratuity or end of service entitlements for domestic employees. In other words, the law, just to summarize, the law does not provide for end of service gratuity. The new law, and this new law canceled out the previous law that had references and had set out a very clear formula for domestic gratuity. And furthermore, the courts, at least based on what we've seen so far, have not been even discussing the end of service gratuity, because that's obviously there's no support for it in the law.
Okay, so this applies to anybody who's been hired as a domestic worker who holds a domestic worker's visa.
Yes, correct. And that's a great clarification. Yes. So this particular law applies to actually the so-called legitimate domestic employees, domestic workers, because in order to work in the UAE as a domestic worker, you need to be sponsored and you need to be employed as a domestic worker. Yeah. That means, in relevant terms, if you're in Dubai, the authority that kind of governs this is Tadbir, and so they're the ones who there's a special contract, employment contract that applies to domestic worker that's issued by Tadbir and kind of registered and managed through Tadbir. And similarly, on the back of that employment contract, for a specific contract for domestic employees, there's also a visa that's UAE residence visa that's issued on the back of that employment contract, which is also basically a domestic employee visa. So this particular law, this law that we just discussed, it applies to those domestic workers who are basically the legal domestic workers, so to speak. Anybody else who, for example, works as a domestic worker but is on somebody else's visa, could it be a spousal visa, could be a company's visa, and there's a lot of people like that here, who, for example, because it's cheaper and easier, let's say some company puts them on their visa, but for all intents and purposes, they're domestic employees, but they have a corporate visa. So those kinds of employees, that's not, technically speaking, that's not a legal way for them to work. But if there was a dispute in that context, they would not be able to benefit from this law. They would have to be claiming employment benefits under the main employment law, which applies to the private sector, which we've discussed. So in that case, they would be entitled to end of service because they would be governed by the actual employment, the UAE labor law or employment law.
Even though their visa doesn't really stipulate that they're doing what they should be doing.
Correct. And
the law applies in that way.
Great point. And that's because these are two different laws, right? Yeah. So the employment laws apply for anybody who is employed in the UAE. And so the employment law and the labor courts will address that aspect and that issue of relationship. In other words, if you worked, you are entitled to get paid. It doesn't matter whether you worked without a visa or illegally or not. So the courts don't look at that as long as the work you perform is legal. In other words, in certain professions that are perhaps less legal or a little more frowned upon here. But as long as it's legal in nature, the work that you do, whether you had a visa or not, that's outside the jurisdiction of the employment courts, and they don't look at that. Judges don't look at that. But if you're working in the UAE without a visa, without the correct visa, that's more of an issue for the immigration authorities. And on that basis, you could be fined, you could even be deported by the immigration authorities, but you'd still be entitled to your employment benefits, by the way. So there's separate laws. So you're correct. That's a great question, but. So in other words, for all those domestic employees who may be working on kind of the wrong visa, if there is an employment entitlement or if they want to claim end of service because they are sponsored by a company versus a domestic employment, they certainly have the right and they should not be afraid of it. But all those legally employed domestic workers, for the time being, there's no more claim for end of service.
That's good to know. What about, let me go back to benefits and back to Federal Decree Law number 9, 2022, the domestic workers law that has superseded all others that go before. Are holidays included for domestic workers, and are those paid under the new law?
Yes, and so in most cases, the new law more or less copies or mirrors the benefits that are set out in the previous law that was canceled. And so holidays, the entitlement to holidays, which is 30 days, was provided for in the previous law, and it's equally so provided for in this law. So yes, holidays always, there's 30 days of holidays per year, and also employers are required to allow their domestic workers to go on holidays every 2 years. So they're not allowed to deny them. In other words, this holiday time, they have to take holidays at least, in the very least, every 2 years. And if they don't, then they have to pay their holidays that they don't that the employer does not take. They have to pay it out. So that's provided for. That's in the law, and that's more or less sort of mirrors the previous provisions.
Okay.
But
what if somebody? I mean, this is still a new law. What if somebody resigned before this law was issued, and they're just working until, I don't know, the end of their contract, the end of their visa? But what if they resigned before this was published in the official gazette? I think that's the way laws are published here.
As long as they're still working, and so if they were to resign, then if you resign, you will not be working anymore beyond the 1 month notice, for example, right? Because if you're working, then you're still working, and therefore, when you stop working, then that's the end of your employment. And so therefore, this law, so if there was a dispute, the dispute would arise as of the time that your employment ends. Your employment ends, right? So if you end December 15th, then the law is already in effect, and so at that point, because remember the importance of this new law is it completely cancels out the previous law. So if you resign, you're terminated, or there's a dispute that arises after the law came into effect, there's no other law to rely on. So if you have a dispute, you have to cite the law. And the only valid law that exists is this law number 9 of 2022.
I mean, there's a reason I ask that. What you find here is lots of domestic workers will be with, say, a nanny with a family, could be with a family for 20 years. That's more than feasible. And that's, clearly a different relationship. But it could well be that, I don't know, the nanny is look, I'm going to go back home, and the employer says, well, can we wait until X child is at a certain point in school? So a notice could have been given, a good bit earlier than, the usual kind of 1 month. That's what I'm thinking, because it strikes me that the relationship between the domestic worker and the employer is a very different relationship between a corporate employer and an employee. In most cases,
for sure, it's a lot more. It's a lot more intimate, right? Because this person lives with you in your house, or in the very least, they take care of your family and they take care of you. So it's a very intimate relationship, and so for sure, it's there's a lot more. Perhaps it's more familial as well. So it's almost like in most cases, you'd hope that it's more like a family member. So therefore, you would be treating them differently. But it's interesting to go back to your example. So. Theoretically, and using that example, somebody who worked for a family for 2 years, that person should have been receiving their end of service every 2 years. Because remember, under the previous law that came into effect in 2017, they would have been entitled to end of service as of 2017, not previously. And between 2017 and 2022, every 2 years, they should have been receiving the end of service. That was the importance of that, or what I thought was a kind of a beautiful mechanism in that law to ensure that employees don't get abused, right? And then also that they have an opportunity to save some money along the way, or to receive some additional money along the way. So as per that law, the end of service had to be paid out legally. It had to be paid out every 2 years, even if you continued on working for the same employee. But every time you renewed your contract, then technically speaking, under the law, you should have been receiving the end of service. So hopefully, in your case, that person would have received end of service from 2017 to 2022, at least that period of time. And more importantly, and to your earlier point about this sort of the very, very intimate nature of the relationship, you'd hope that if somebody has worked for you for 10 years and that they've made special accommodation to stay with you and your family to help you out until your children are grown up, or whoever it is that in your family that needs help, that the family would do them right and would take care of them, and whether the law changed or not, that benefit, obviously, that benefit is always optional. And so the family could offer that optional, so as an optional benefit. So you'd hope that in that case, the change in the law would not affect that relationship.
There is always hope. But that's another episode of Lawgical, this time end of service benefits for domestic workers here in the UAE, of which there is no mention under the new law, UAE Federal Decree Law number 9 from December 2022. As always, thanks for listening and watching, or both, and thanks to our legal expert, managing partner here at Yamalova and Plethka, Ludmila Yamalova. Thank you.
Tim, thank you. Great being here with you.
Find us at LYLAW, social media, Facebook, Instagram, TikTok, LinkedIn, YouTube. You can find all our podcasts at lylawyers.com. If you'd like your legal question answered in an episode of Lawgical, or you'd like to talk to a qualified UAE experienced legal professional, click contact at lylawyers.com.